Sometimes the problem with an estate is not the paperwork, it is that something went wrong. A will changed at the last minute under suspicious circumstances, money that has gone missing from the estate, an executor who will not account for what they have done. When a dispute like that lands in court, that is probate litigation. I am Asthana from Southern Estate Lawyers, and we litigate estate disputes across Alabama. Let me explain what this is and when you need it. Break the term in two: probate and litigation. Probate is the process of settling someone's estate after they die. Litigation just means a dispute that goes to court. Put them together, and probate litigation is a court fight over an estate. Here is the distinction that matters. An estate planning attorney drafts wills and trusts. A probate litigator goes to court when those documents are challenged. Many firms do one or the other. We do both. Probate litigation covers a range of disputes. Will contests, where someone challenges whether a will is valid. Trust disputes, litigation over how a trust is administered, managed, or created. Claims of undue influence, where someone pressured a vulnerable person. Breach of fiduciary duty, when an executor or a trustee mismanages the estate or trust. Accounting disputes, when a beneficiary has the right to know how an estate is being handled, but the executor is slow, evasive, or simply refuses to produce records. Creditor claims, where there is a dispute as to whether a debt of the estate is valid, or whether it's being paid in the right order. Recovering property that was wrongfully taken from the estate, or fights over guardianship and conservatorship over who controls the affairs of an incapacitated person. A lot of probate litigation centers around the person who is in charge of the estate. In Alabama, the executor or administrator is a fiduciary. The law holds them to a standard of a prudent person handling somebody else's property. They must act for the estate and never for themselves. Alabama law spells out what can get an estate executor removed, such as wasting or embezzling estate assets, using estate funds for their own benefit, failing to keep records or account for what they have done, a conflict of interest where the executor has a personal stake in a transaction involving the estate, and maladministration of the estate, broadly a catch-all for conduct that falls short of the standard that the law demands. If an executor crosses that line, a court could remove them and order them to pay what was lost. The most common disputes involve undue influence and capacity. They often travel together. Picture an elderly patient in declining health. A will or trust suddenly changes late in life to benefit one person who was close at hand, often a caregiver. When someone in a position of trust overrides what the person truly wanted, that is undue influence. And when their condition left them unable to understand the nature and effect of what they were signing at the time, that is a capacity problem. Undue influence and capacity reinforce each other. Where these cases are actually heard matters more than what people expect. In Alabama, probate courts handle estate administration, along with guardianships and conservatorships. But where a contested fight is heard depends on the county. In most Alabama counties, the bigger disputes can be transferred to circuit court. But in some counties, the probate court judge is a licensed lawyer and has equity jurisdiction. And in those counties, these big disputes, they stay in the probate court and cannot be transferred to the circuit court. As of now, that includes Baldwin, Mobile, and Jefferson counties, though this can change depending on who is elected to the bench. Using a lawyer that knows the local courts and which rules apply in your county is a real advantage when it comes to these disputes. Let me be honest about what litigation is. It can be expensive and it can be slow. And no lawyer can promise you a particular outcome. That is exactly why the first thing we do in your free consultation is tell you whether you actually have a case. Sometimes the right move is to fight, sometimes to settle or walk away. You deserve a straight answer before you spend a dime. As Southern Estate Lawyers, litigation is our strong suit. We represent beneficiaries and heirs who believe that they were wronged. And we represent executors and trustees defending their administration. We are active litigators across Alabama, probate courts and circuit courts. We investigate, gather the evidence, and we build the case. We push for an efficient resolution where it's possible. And if a case has to be tried, we are ready to take it to trial. We have offices in Mobile, Foley, and Birmingham. And we serve families across Alabama. If you are caught in a dispute over an estate, whether you're challenging what happened or defending your role, the deadlines move fast and the stakes are high. Call Southern Estate Lawyers for a free consultation. We look forward to working for you.